One.但最后你可以帮我们合照吗？可以。Okay, so as we stay in the event, everyone in the event, right? Yes, you look at the You want to come over? I don't see the back. Yes. I mean, what do you Yeah.
要再等一下。
Yeah. I can help that. Yes. From
Now 是利用。
好 ，OK，
对。
这到时候我们来出脑牌哦。
Okay, should we get started? Okay, excellent. Okay, so this is one of the most exciting panel. Okay, well, thank you very much for joining our panel, Shaping Rules for Inclusive and Sustainable Trade, New Global and Regional Approaches. And we are very glad that our proposal was accepted by the SIEL Global Conference. They made a good choice. So because we'll be talking about emerging norms for inclusive and sustainable trade as they represent a new phase in international economic law, which include both WTO agreements and regional frameworks. And as you know, the preamble to the Marrakech agreements includes a commitment to sustainable development. However, most academic and policy discourse has primarily focused on general exception within the WTO agreements and important disputes such as the shrimp turtle case. Since 2015, the UN SDG, Sustainable Development Goals, have redirected trade agenda away from the traditionally neoliberal economic paradigm. So let me first explain what we mean by sustainable and inclusive trade. Well, underpinned by the SDGs, the goal of sustainable trade is to foster long-term growth built on economic, social, and environmental pillars. And embedded in sustainability, inclusive trade emphasizes the equitable redistribution of trade benefits by reducing barriers for marginalized groups, including women, liberals, indigenous peoples, and MSMEs. And this shift has moved attention beyond the traditional focus on special and differential treatment provisions for developing countries. Moreover, the deadlock in WTO negotiations has ironically spurred innovative regional approaches that shape the evolving norm that we talk about. Given these fundamental changes, and our panel goes beyond WTO initiatives to address the latest plurilateral and sectoral agreements, such as FTA, African Continental Free Trade Areas, new EU agreements, the CPTPP, and the IPECA, Indigenous Peoples Economic and Trade Cooperation Arrangement, to which Australia, Canada, New Zealand, and Taiwan are parties. And importantly, the United States has joined as an observer, and Trump has yet to withdraw the US from the agreement? Not yet. Yes. Yeah. Trump is very busy with other stuff. Yeah. And there are also new sectoral agreements that form part of what I call green regionalism. This includes the Singapore-Australia Green Economy Agreements and the SECTS, the Agreement on Climate Change, Trade, and Sustainability. So we are not just examining the EU's typical approach of enforcing sustainability provisions under FTA. That's what Europeans like to talk about. Yeah. Instead, we are exploring much broader perspective on how inclusive and sustainable trade affect global and regional supply chains and enhance value in trade in a more pragmatic way. So, and today we are very privileged to have 5 excellent panelists who will share their insights on this very important topic from both global North and global South perspective. And I will invite each of them to speak for 8 minutes, and we will have time for a Q&A. And first, let me invite Olabisi Akinkugbe, who is teaching at Dalhousie University, Canada, and Olabisi is also SIEL's vice president. Okay, you have 80 minutes. Come over.
Thank you. So is it better to? No. I think it's better to stand. Is that how? Is it better to stand? Okay. Okay. So thank you, Pasha, for putting the panel together, and it's nice to join everyone else. So I think in my own reflections for the 7 minutes or so that may be left, I'll focus on the African Continental Free Trade Area Agreement. And for those who don't know about it, it was maybe about 5 years ago, the biggest thing that happened on the African continent. Right now, I'm not too sure it is the biggest thing that happened, but the implementation is on in some form or version at the moment. It has various protocols that have been negotiated as part of the phase 1 and phase 2, and those in the phase 2 comprising primarily of the investment protocol, those relating to intellectual property, competition, gender, are all in various stages. But really, the typology of those agreements and where they are is not the focus of the conversation. So really, it's about the notion of inclusion and sustainability in those agreements. And there's no time to really try to look at all of them. So I'll focus particularly on the protocol on investment trade, which I think may be of interest, hopefully to all of us here. So the question of sustainable development clearly is a very contentious subject and not one that I think we hopefully would disagree on that statement. Whether we think about it in the context of the environment or the context of economic development or that of the social, these questions have bothered African countries and developing countries broadly. The idea that it can be surmised, in its entirety, whether it's in the notion of sustainable development, I would like to start with actually understates the significance of what the states need to do. That is more so because when we think about the notion of sustainable development in the context of investment law generally, there's a whole lot we can talk about the problem of whether investment should facilitate economic development. But because I'm going to focus on the protocol on investment, it's important to sort of start by saying, you might look through that agreement and you will count how many times that sustainable development was mentioned, at least 24 times in it. Now, that doesn't move the needle on the implementation of the sustainable development goals, nor does it do anything quite differently if that is all one looks at. So there are certain provisions in the agreement itself that actually aims to move the needle, particularly on the question of what is investment, for which there is an obligation on the states to actually make sure that whether or not a particular form of investment qualifies as investment under this particular agreement or protocol must satisfy those goals. Let's bear in mind, this is geared towards intra-African particular economic relations in particular. And so Article 1 of the Protocol on Investment notes that sustainable development embodies economic development, social development, environmental protection pillars. So with Pasha's opening statement, you can see, they followed what is the norm in most investment agreements. But particular relevance is this one, which I'd like to focus on around Article 7. Of which there is, Article 7 is the one that required the mandating of the negotiation. Article 7.1 requires that the states parties, quote, have to facilitate investments that contribute to sustainable development. The question here, maybe I should read some of the other provisions before I then come to my two reflections on them. If you go back to Article 1, it requires that to qualify as investment, the investment must, among other characteristics, make, quote, a significant contribution to the host state's sustainable development. So it looks like at some point we're already in the game of, just throwing words out there. But it does more than that, because if you look at the first point I'm going to make, which is the idea that there's actually something innovative about what that agreement did, which is that unlike what we who like to write about investment law generally think about the contentious question in academic debates, it is clear that an investment won't be characterized as such until it meets what a particular state describes as fulfilling not just its sustainable development goals in the context of SDG, but its own peculiar economic development and environmental concerns as well. So an investor, for example, will have to satisfy Nigeria's local laws in relation to its environmental EIA, depending on the sector you want to work in. For example, if it's an extractive sector, that could take a lot of time to really go through that threshold. That really is where I like to leave it on the agreement itself and come to 2 points, right? As much as one would like to celebrate this particular agreement, in my mind, it raises the very big question around sustainable development promise and reality, as I describe it, challenges, right? There are promises a lot around what good would come out of prioritizing environmental concerns, social inclusion, economic development. But the reality, though, is that if we look at how developing countries operate, and to take in particular here, the extractive sectors, I'm not even talking about critical minerals as we know them today, to go back to fossil fuel era extraction of oil and gas. There's no world in which that will really happen. If you're to think about the fact that they'll need to put ahead all the environmental regulations and hoops they'll have to go through before you can then say, okay, come in and come and explore, right? So it's either, we have missed a step and be driven out of what we should think about in here as maybe compliance with our environmental regulations, maybe on a state-by-state basis, right? Rather than saying until you meet it and then the state characterizes it as that. So what looks like innovation on the one hand actually meets reality and becomes almost an empty promise. The second point I want to make around this is the fact that if we step forward a little bit and think about this sort of investments in the context of an already polarized regime in the African context, there's no new place to go into where you're going to start afresh in terms of investments if we move the page on critical minerals now. Right? And the second point I want to make in there is that to the extent that narratives around sustainable development, valorizes all these ideals about the fact that they'll protect the environment, they're good for gender concerns, and so on and so forth, I think the development aspirations of many African countries really remains at stake. And I do think as much as those issues are desirable, maybe for intra-African trade agreements, they have set the threshold too high. Thanks.
Yes, it works. Thank you very much, Pasha, for the introduction. Today we'll discuss emerging trade trends in addressing forced labor in global supply chains by focusing on forced labor good bans. In the interest of time, I will mainly focus on the US and EU measures in this regard, even though the paper I'm currently working on also explores Canada and Mexican ban in this regard. My presentation is structured following these three main questions. So how do forced labor good bans work and what are their key features? How and to which extent do they differ from existing well-established trade measures that we have addressing forced labor traditionally, and to what extent also these bans represent or can represent a normative evolution in the trade and labor nexus, and also which are the challenges that they, of course, pose. Let me briefly give a definition of forced labor good bans. In a nutshell, they are domestic trade restrictive measures that restricts the importation and in certain cases also the exportations and more generally the marketing of goods which are believed to be produced wholly or in part with forced labor. We have several examples. We can date back to Section 307 of the US Tariff Act of 1930, but more recently in time, the EU has adopted in late 2024 the EU Forced Labor Regulation, which is expected to enter in force in 2027. But unlike other measures the panel will address today, it is so far has been left untouched by the omnibus regulations, but with the omnibus package, but we'll see. Now, if we compare them through a comparative lens, what we will see is that all these bans they tend to align, let's say, on several features, even though they display different regulatory designs. I won't have time to go through all the nitty-gritties, but just to name a few in terms of similarities, all these bans define forced labor by explicitly or implicitly, in the case of the US, to the international definition of forced labor, which is enshrined in ILO Convention 29 on the elimination of forced labor. Now, it is yet to be seen whether defining forced labor using an international agreement is the most efficient things to do. It is an international standard. It is not a domestic standard. So there is no definition, let's say, of domestic EU definition of forced labor. But at the same time, extrapolating the international definition from an international agreement, which was meant for states and not from economic operators, might be a little bit challenging. This leads to the second element of these measures about their firm-centric approach. They put at the core of the measures the behavior of economic operators within global supply chains, usually without any kind of distinctions between multinational SMEs and so on and so forth. So again, there are no thresholds in terms of of turnover or size of the work force, but they really link, and this goes to the third element, human rights due diligence to market access. Interesting enough, all these bans do not introduce binding legal obligation to perform human rights due diligence, nor they request ex ante at the time of the importation of the delivery of such documentation. Nonetheless, it is crucial because only through human rights due diligence, documentation, and economic operators is able to basically lift the ban, rebut the presumption that goods are made with forced labor, if we think about the Uyghur Forced Labor Prevention Act, or to block at the preliminary phase of investigation in case of the EU Forced Labor Regulation. Going to instead to the divergences, there are several. I will just focus on two. Of course, we can distinguish forced labor good bans between import bans and marketing bans, and I think this is an important distinction also in terms of WTO law compatibility. The EU Forced Labor EU Forced Labor Regulation is a marketing ban, so it does not only block prohibits the importation of goods made with forced labor, but also the exportation. And it is a general marketing ban, so it applies also with goods which are with EU origin or without EU origin, whereas on the other cases, we just have an import ban, which doesn't apply to goods which are, for instance, US made. And another important fact, which is related to the trade restrictiveness of such goods bans, is about the allocation of the burden of proof. So we can go to one end to the UFLPA, so the Uyghur Forced Labor Prevention Act, where the burden of proof lies entirely on the economic operator, which has to rebut the rebuttable presumption, while on the other hand of the spectrum, we have measures such as the EU regulation or the Mexican ban, in which the burden of proof lies on entirely basically on the national competent authority, which has to conduct the investigation, and then if it can decide that the goods have been made with forced labor, it can then issue the import ban or the decision blocking the marketing of such products. Going to my second question, which is how to differ from existing instruments addressing forced labor, the main idea that I would like to convey here is the fact that I think there is room to argue that there is complementarity between labor-related provisions in free trade agreements and GSP conditionalities related to labor commitments or the implementation and ratification of ILO conventions and the forced labor good bans. So a question that I think we have to address more and more is how we draw the interplay between unilateral trade measures on environment or also on social sustainability and the commitments that we already have in several free trade agreements, for instance. And the fact that the complementarity, that they are complementary, is built to the fact that if you look carefully, there is a different focus in these two categories of measures. So on the one hand, we have state-level enforcement gaps, which are addressed by labor-related provisions, for instance, in some free trade agreements, while on the contrary, with forced labor good bans, the focus is more on responsible business practices, which leads me to my last point about to what extent these forced labor good bans represent an evolution in a trade and labor nexus and what are the challenges that they pose. I think the implementation for the trade and labor nexus are mainly two. To the one hand, it brings the trade and labor nexus to a more multifaceted approach, whereby it is more and more clear that in order to have more sustainable trade, we need not only states, but also non-state actors on board in a way. And the second one is that since forced labor good bans, it is true, they do refer to ILO definition of forced labor, but they nonetheless are more anchored to business and human rights regimes. So the idea of human rights due diligence, the idea that responsibility to protect human rights from economic operators is really at the core. And so I think it broadens up a little bit the horizon, let's say, for the trade and labor nexus toward not simply thinking about the WTO ILO axis or nexus, but more also with business and human rights. Of course, plenty of challenges. Happy to discuss this part during the Q&A. The tensions, a lot of tensions with WTO law and particularly with GATT principles. The legitimacy, which is of course linked to the extraterritoriality, and there are some and many practical implementation challenges. These are not easy measures to implement. They are not cheap, inexpensive to implement, besides the political willingness to actually use them. Thank you very much for your attention.
Is it on now? Oh my gosh, it really is. Thank you, Pasha, for the invitation. As Pasha said, I teach in the US and New Zealand, and the less said about the US, the better. So I'm focusing on New Zealand today. The theme of this panel is sort of new ways of addressing different types of rules. And New Zealand has really been at the forefront of innovating in this space. So I thought I would just take us through that a little bit. So New Zealand has named its strategy Concerted Open Plurilateralism. This is a strategy basically of finding coalitions of the willing and coming up with something that you have a shared interest in, designing some rules that you all agree with and that you think you can, and you then try to structure your agreement in a way that is likely or ideally will attract others to join. And if we can think about this we can contrast this with perhaps the country that will not be named approach to FTAs in the past, which is sort of to have these Frankenstein provisions that are very much geared towards the particularized interests of, one of the parties. So we'll have, we'll reduce tariffs on most products, but for certain products we won't, or we'll have really onerous rules of origin that effectively doesn't liberalize that. But New Zealand's approach basically is not to do any of that sort of stuff and to have sort of pure, uncomplicated types of rules and agreements that have a clear objective in the hopes that that will attract others, as opposed to having something that is so bespoke that it clearly would not attract others. So while I'm going to turn to some examples of sustainability and environment in a moment, I did want to note that New Zealand's strategy has been in place for a very long time. And if we think about, people know about the TPP or the CPTPP, but the origins of those agreements lay in an earlier agreement between New Zealand, Singapore, Chile, and Brunei of all countries. And now we think about FTAs as sort of crossing the globe, but back in 2005, it was pretty bizarre to have this agreement that linked countries that were not neighbors. But the idea there grew out of earlier talks in APEC between New Zealand and Singapore, and at the time, US and Australia as well, about how can we have sort of a model FTA with the thought that this could grow towards a free trade agreement of the Asia Pacific. That was a goal for a long time in APEC. It is still notionally a goal, although the contours of the goal have shifted. But this agreement, the Trans-Pacific Strategic Economic Partnership between New Zealand, Singapore, Chile, and Brunei, was a very advanced agreement for its day. There were no exemptions of any products from the market access liberalization. It was designed, it had an open accession clause. The idea was to encourage other countries to join. And their hopes was that this could provide the nexus for a broader Asia-Pacific agreement. Ultimately, that agreement was by design intended to broaden its own context to include investment and financial services. And at the time those negotiations commenced, the US said, we'd like to sit in and see what's going on, and maybe we'd like to join. And that led to the dominoes falling and the TPP negotiations happening. Of course, that fell apart. But again, New Zealand took a very pragmatic approach to the US pulling out. Under the terms of the TPP as negotiated, it could not be ratified and come into force once the US pulled out, because the TPP itself required 80% of the GDP of the TPP signatories to ratify for it to come into force. When the US came out, that meant TPP couldn't be ratified. So the other countries talked about this, and Japan said, well, at first said, well, we're not sure we want to deal with this if the US is out, blah, blah, blah. Should we just renegotiate? Because a lot of this, there are provisions that were US demanded, and if the US is out, do we really want these things? And it was actually, as far as I'm aware, Tracy Epps, who was the moderator of the last panel, who came up with the idea that, like, hey, she was one of the negotiators, why don't we freeze the positions that were the US-centric ones that we don't like, and just keep things simple and have the TPP as it was, save for these provisions that we'll freeze, and that makes it easy for the US to come back in later, should it choose to do so. So it's, again, sort of really focusing on preserving the ability for the agreement to expand, and of course, now it is expanding. So this has been New Zealand's approach, and New Zealand has taken this approach in FTAs, but also in other strategic locations. So within the WTO, it's participating in all the JSIs. but also in APEC, it has looked for opportunities to try to get things started in just discussions outside the WTO or any formal structure. And as it says here, the goal is go out there and find things where we have commonalities with other countries and see if we can get a spark, to form. So I'm going to characterize sort of the recent initiatives as being bottom up, but I don't really mean necessarily entirely bottom up, but just sort of maybe the catalyst has come at not from starting from the WTO, not starting from an FTA negotiation, not even starting with an APEC necessarily, but just, hey, we think this is a good idea. Do you think this is a good idea? Let's go. So just a few examples here. I won't read all the stuff on the slides, but one is ACCTS, which Pasha mentioned briefly. This was actually launched by New Zealand in 2019. This itself, in a way, probably the germination of this came from within APEC, where back in, I think, oh gosh, maybe it was 2010, APEC agreed to remove tariffs on certain environmental goods, which became, in a way, the catalyst for the environmental goods negotiations in the WTO. And so ACT kind of goes beyond that still. Another is IPETCA, which is an Indigenous people's cooperation agreement, which is super interesting. As Pasha said, includes Taiwan, includes Canada, Australia, New Zealand, and the US even participating as an observer until someone tells our president that this is going on, in which case maybe we'll stop observing. But also launched by New Zealand. Next, there's this framework agreement called ITAG, again, formed by New Zealand with others, with the idea of having sort of a structural agreement, which includes the countries listed, to promote ideas to be identified, but things that have to do with sustainable development, gender issues, all the issues that we're talking about today, sort of these non-economically driven necessarily things. And ITAG has launched a gender initiative thus far. And then New Zealand has also been at the forefront in negotiating this digital economic partnership agreement, which provides, again, a framework. It's a modular system where they've agreed to a bunch of provisions that seem like a good idea to have in digital agreements. And the idea is that other countries can just take those provisions as they wish, pick and choose, plug and play, build your own Lego, and come up with a digital trade agreement. And so I just throw this out here as an interesting example, because instead of sort of previous FTAs where the US or the EU might be pushing their own templates and ways of doing things, here we have a small country that wouldn't be a demandor in a negotiation like that, sort of blazing new paths and ways of doing things. That's it.
Okay. Good afternoon, everyone, and very thanks for the Pasha's invitation to join this panel. And this panel, I think, is very quite interesting. And actually, our presentation actually are linking with each other. So I believe that probably later we will have a very interesting discussion. And my topic here actually will related to the Meredith, his topic, like some interesting and novel ideas emerged in Asia Pacific, especially led by New Zealand. So I just want to use this topic and actually to focus on the IPECA. And but before entering into that specific arrangement or called informal agreement, we must to ask one thing, that why we need to address indigenous people's rights in the trade context. And so before to answer this question, and we can just see that actually they have the regulatory approaches shift in international economy and law. I think that before 1995, the international trade and the international investment law, we believe that actually trade only for trade, investment only for capital movement. So since that business is business, so of course that when everybody can just get health, and of course we can just address the social and environment issues as the side effects. And so actually, in the GATT, the General Agreement on Trade and Traffic, that's actually they just to establish a very traditional way to address the non-trade issue is the exceptional clause. So the exceptional clause that actually he only to address the two issues. One is environmental protection, another is labor rights. So the labor rights actually is quite interesting because actually it's part of human rights. So, but before the 1995, that will be the one human right actually be recommended in the trade agreement. And then he just expanded his coverage to from the several individual clauses into one specific chapter. So, but those countries, they usually think the trade linkage issue only to focus on environmental issue and labor right, only the two non-trade policies. But after the 2015s, the SDGs come in. Actually, he just bring a more dimensional conception to development policy. It's meaning like the one government they must to strike a balancing among economic, social and environmental values. So it's not me. It means like actually it's just to open a door for a very wide range, a wider range of the non-trade issues into the context of the trade and the investment. So after the SDG, that actually we can see a new scenario. It means like we must to highlight and even to preserve the right to regulate by the governments, and it must to express and to provide and to recognize this right to regulate for all countries in trade agreements. So that will be followed by this new scenario after the SDGs in 2015. So we can see that actually from the 17 SDG goals, actually his job bring the two things. The one sustainable, another inclusiveness. Inclusiveness actually it will be equal to the human rights, not only the labor right, but other people's right or communities' rights. So here comes in the indigenous peoples. But the indigenous people actually, from my point of view, it will very specific and very special human right, because indigenous people's right is combined two kinds of human right. One is for individual rights. It means that we have the freedom for speech, we have a freedom to move. That's for individual. But another kind of the human rights is a collective rights. It means that you must to recognize the one community that have a right to regulate their self-affairs. They have a right to self-governance. So that will be a collective right. Actually, it will be my especially interested topic because it probably will have the potential conflict between the right to regulate of the contracting party to a trade agreement, but it also will have the right to regulate by indigenous peoples if they really be engaged in trade agreement. How we can to strike a balance between the two rights. And the most fundamental question is, could this kind of collective right could be reconciliated or could be harmonized in trade agreement? So that will be the questions that why when we want to bring the indigenous people's right into the trade agreements, they have several very critical issues that we must to address. But before entering into like the deep water, I think that the APECA, he just want to do the first thing. The first step is that we just discuss what is will probably be the trade policy. It will relate to indigenous people's rights, and what kind of indigenous rights or indigenous affairs it will relate to trade and investment. So the APECA he just to pave the way like to how to bring a policy framework first. And then under this framework, we will talk about the policy cooperation and the collaboration. We not to talk about regulation, harmonize, not. Harmonization of a regulation at domestic level is not the critical issue under this arrangement. I think the critical issue under this arrangement, he wants to set up a regional platform or the plurilateral platform for those participating countries to negotiate and to export the ideas that how we really can try to address indigenous issues in the trade and the investment context. So I think that they have the interesting point that will just like the Meredith he mentioned. Under this arrangement, he just have the specific linkage with the APEC. I think it's a really special character of this agreement. If we can just call a kind of new trade agreement, that will be this the first arrangement he just mentioned that how could we try to cooperate with other regional institutes and to facilitate this kind of the policy. So I think that for APEC, there are two implications, I think, that from this arrangement, these are new approaches. One is for the trade policy. The first that he just explained the trade issues to indigenous people's rights, and that will be the mix between the social and environmental the issue under the indigenous people's rights. And then he just shifted the trade agreement to the sectoral specific agreement. And also he just highlight the policy cooperation instead of the trade liberalization or even the harmonization of the domestic rules. And for indigenous people, because that actually before that, they at the margin of the international economic system. But this agreement, he wants to recognize its role and is very important to the environmental protection and as well as the international economic system. So I think that they have the two positive ways that of the APEC on the international economic law. But of course, they have some challenges. Is the unsettled issue. The first is what will be the specific trade norms like addressing the indigenous rights. But before you want to the specific trade norms, you must to identify the coverage, the scope of the indigenous rights, especially as I mentioned before, collective rights, how much those those contracting parties, they are willing to compromise his sovereignty to indigenous collective rights. And then, of course, compliance and enforcement mechanism. Probably it will be the further and then the next step. Those parties to APEC need to discuss and to explore. So that will be my sharing today. Thank you.
Well, good afternoon, everyone. Very happy to be here today. And thanks a lot again to Pasha for convening this panel. I have to say I found all the presentations very interesting, and I'm the last presentation before the Q&A. So I hope not to disappoint and to get questions from the audience as well. So I'm going to talk about EU legal instrument called the Corporate Sustainability Due Diligence Directive. So it's a bit of an Eurocentric approach, but you will see very quickly how this legal instrument actually has far-reaching implications for suppliers and companies all around the world, which is why I think it's relevant in the context of the discussions we're having today on sustainability, but also accountability for what are environmental harms and human rights harms. And we heard how these, can be addressed under several frameworks, But also we will look at the global supply chains, and Ilaria talked a bit about this. I'm going to focus more specifically on this instrument that actually does not focus on one human rights violation specifically, but on any types of human rights and environmental harms. Now, the first thing I should say is these corporate sustainability due diligence directives does not come out of nowhere. In fact, John Ruggie, that some of you work in the human rights space may have heard of, he started with the UN Guiding Principles on Business and Human Rights in 2008. And then after that, at the domestic and international level, there were several instruments that were adopted to address human rights and environmental harms. We fast forward now to 2024 when the CSDDD, as it's called, the Corporate Sustainability Due Diligence Directive, entered into force. How did we go from what were soft law guiding principles to hard law? I think even John Ruggie, who passed away before CSDDD was adopted, would have been really quite impressed by the fact that in the scope of not even 20 years, we went from soft law requirements to hard law requirements. So this due diligence directive essentially creates stringent requirements for companies not only based in the European Union, and we're talking about large multinationals, I should say that to begin with, but not only large multinationals based in the EU, but also large multinationals that have a significant turnover in the EU. And already here we see the extraterritorial reach of this instrument, which is why even though we're talking about an EU law instrument, actually it involves companies based outside of the EU, simply because they generate this type of turnover in the EU. So this is the first aspect. We are asking companies, both based in the EU and based outside of the EU, to make sure that they avoid human rights and environmental harms from occurring not only where they operate, not only where they are based, not only in the activities of their subsidiaries, but to make sure that any of their suppliers is not involved in any environmental or human rights harm. Now, this is, again, very far-reaching because we're also talking about suppliers that could be a one-off supplier, one company once that provides bananas to supermarkets that are based in the EU. And how are you going to be able to tell that actually, that supplier is possibly involved in this type of harms? Now, the second very important aspect is once you establish that this harm could be occurring, you should take steps and ideally mitigate harms if they are already occurring, but even better would be simply to prevent those harms from occurring. How do you do that? Well, you suspend relationships, or sometimes you even terminate the business relationship you have. Now, this legal instrument has been subject now, and Ilaria mentioned it, to a proposal from the Commission that was presented in February and has just been accepted by the European Council a couple of weeks ago, that essentially watered down all these hard law requirements that were included in CSDDD. And why? Because we were talking about inclusiveness today, I will look at the omnibus package, as it's called, this proposal from the EU Commission that has watered down CSDDD. Essentially, if you're looking at inclusiveness from the point of view of these suppliers based around the world, well, once you say that you terminate a business relationship, well, you're not very inclusive because what you're saying is every time there is a risk of human right or environmental harm occurring abroad, you should suspend or terminate relationships. And on the one hand, the EU has very good reasons to do so. It's trying to, ask its companies and the companies that generate turnover in the EU to raise the standards, to make sure that in their operations worldwide, those harms do not occur. But if you look at this from the point of view of developing countries, they find that this extraterritorial reach of the directive raises concerns because a business based in Europe may, at the first suspicion that there is potential human right or environmental harm occurring abroad, may say, well, I turn to a different supplier. And that obviously may have far-reaching economic impacts for these suppliers based above. So if we look at inclusiveness as the concept through which we look at CSDDD, well, it's problematic. So the Commission essentially, in the current geopolitical context, said, I think essentially, and not the Commission just, because it decided to do so, because the member state were putting pressure on it, said we might have gone too far too quickly, and essentially decided not only to limit CSDDD to a fewer number of companies, they also raised the economic threshold that essentially makes non-EU companies to be captured. But also they said, let's not talk about terminating relationship. Let's find different ways to deal with this. And they also killed off an important provision, which was on civil liability for those companies that were not complying, essentially bringing the clock back in time and bringing us back to what are hard law requirements, but not as far-reaching as they used to be. Now, I will finish with this, whether this is an issue from the point of view of respect for human rights and environment and protection against environmental harm, or whether you look at it from some suppliers and developing countries' point of view, saying, I think this makes more sense because we need ways and time, to discuss how best we can, raise the threshold. I leave it to you to develop your own opinion and perhaps discuss this in the Q&A. But these are the facts that I provided you with, and I think both views have merit. Thank you.
Well, thank you so much, Tibisay. Okay. Well, I myself have a lot of questions for you, but let me collect questions first. Okay, please.
Thank you. Congratulations for this wonderful panel.
First of all, identify yourself and yeah.
Sure. Amrita Bahari, ETAM University, Mexico, and the WTO academic chairholder for Mexico. Now, I have two questions for the entire panel. Cannot miss the opportunity of hearing their thoughts on, really the boiling issues when it comes to inclusive and sustainable trade. So yeah, my first question is rather broad and quite vague. Olabisi, you made the point on, the difference, the very vital difference between promises and reality when it comes to inclusive and sustainable issues and within the context of investment. And yes, that's absolutely right. And it's, so I guess, I'm curious to see if you have any thoughts on, how should we make these innovations meet the reality, or should we, right? How can we really walk the path and move closer to reality, and maybe adding them as promises is a way to start, but how do we, make them move closer to reality? The second question is more about the enforcement. I was thinking, during the presentation on the forced labor goods, how, and this clearly being an inclusive concern, we have such strong enforcement mechanisms when it comes to labor standards and forced labor goods standards and others. In different trade agreements, in USMCA, we have this huge rapid enforcement mechanism. So countries have taken these inclusive concerns quite seriously, right? But that's not been the story for the other inclusive and sustainable development concerns. Talk about indigenous communities, talk about disability, talk about gender, women, race, color. They're far behind, not enforceable, very vague, very abstract, zero intention to act upon them, Cinderella promises, window dressing attempts, right? So, my worry or my curiosity here is, are we missing the point? Should they catch up? or I mean, that, and I agree. I mean, labor and trade clearly are related. And maybe that's why countries have found it easier to enforce labor provisions in trade agreements. Maybe we have not been able to prepare a business case for other inclusive and sustainable development concerns. Maybe that's why they are not enforceable. They are just white tiger promises in trade agreements and investment agreements. But so, yeah, that's, yeah.
Thank you so much, Rita. Yeah, we have a question over there. So my colleague reminded me that we need to use, because we have an online participant, so we need to have mic.
Thank you. Franziska Zucker from Wits University in Johannesburg. I have a question to Bizi. Obviously, you said that you think it maybe is too much what they wanted with the provision of sustainability in regards to the investment protocol. So I was wondering why it is like this in there in the first place. So we have seen in other places that the EU has advocated a lot for sustainability provisions in FTAs, and here the AFCFTA is very much lobbied by, arguably, I didn't want to say that as a fact. We know that it was involved in negotiations through stakeholders and funding. So is that maybe a reason why we want too much in the AFCFTA, or is that, do you have any information why it is formulated that aspirational?
Yeah, more questions?
Thanks, Thanks, Pasha. My name's Liz Sheargold. I'm from Monash University in Melbourne. My question is for Meredith, but it might also be relevant to Ying-Jun with your presentation. I really loved the whole panel. It was all super interesting.
Thank you.
And I think looking at, especially the chairing, Pasha, I think looking at New Zealand's leadership in these agreements is so fascinating and so important because they're really interesting to see. And you described the sort of concerted open plurilateralism strategy as sort of starting with a small group of like-minded countries, but hopefully expanding and kind of proliferating these norms. Do you see any difference between the agreements that are more traditional trade agreements in the sense of being binding trade liberalization obligations? So CPTPP and the Agreement on Climate Change, Trade and Sustainability, which has binding obligations on environmental goods and fossil fuel subsidies, as opposed to other agreements like, say, the IPETCA, which Ying-Jun also talked about, which is more of the cooperative, soft law approach. Do you see those as also having the same potential to bring in more members to grow? Are they a step towards hard law, or is that cooperative approach in itself sort of valuable to New Zealand and its partners?
Yeah, thank you very much, Olabisi. More question?
Junji Nakagawa from Chuo University. I have a very simple question to Meredith. Why New Zealand? What is the driving force of its very, very innovative rural entrepreneurship? I'd like to know the reason why.
Maybe final question for this round. Okay.
Harrison Body at the Luxembourg at the moment. So briefly, not quite. Okay, I moved this side, yeah?
I told you better. There's a feng shui problem here. Yeah. Yes. Yes.
Okay. I think mine is whether the question of sustainable development is a question of inclusivity, really. But the active think about now I'm a mainstream. If the SFTA might be the gender and youth protocol, which maybe you can say a word on. And I know that the big concern has been why, for example, we decided that, gender, which sometimes in our part of the world is associated with women empowerment necessarily, is to be saying they don't want to be put together with the question as part of the gender concern, and the general gender-based implications, or people who study gender are saying, why are we, merging gender and youth? Maybe you can, yeah.
Okay, we have exciting questions. Okay, so let me first give each panelist 2 minutes. This is soft law. Okay, for answering the question. Okay, Basic, you go ahead. Yeah.
Okay. So we stand, right? I think it's the way to just face here. So I think the questions are all very interesting. And I think the way I would do it is maybe start with Harrison's question. So I think clearly inclusion falls on the second and third point you noted about youth and gender. And I deliberately sidestepped those ones because they're not issues I have focused on in my own research. Amrita is a leading scholar on gender issues, but clearly that's inclusion, right? But on sustainable development, that traverses many of the agreements, right? It's not about to what extent has any one of them, in my view, not actually mainstream, but somewhat effectively, right, incorporate it into the regime of trade and investment in Africa, right? And that I don't see us doing very well. Or at least to then move it into Francesca's question, the extent to which we have done it seems to be overzealous, in my view, right? We have written an agreement that's supposed to facilitate intra-African trade agreement. What's this threshold we are setting, that makes it virtually impossible for you to even draw investment? Without those kinds of provisions in any trade and investment, it's already so hard to draw the most important kinds of investment, right? So I think, I agree with you, Harris, on youth, gender, those are inclusion questions. But sustainability, sustainable development question, I think is more pervasive in the way it flows once we're thinking about the trade agreements. So for Francisca's question, why is it that, I'm not sure, you would recall when we had the Pan-African Investment Code, which was not, which did not become legally binding. We celebrated this sort of, inclusion of sustainable development, and it's what everybody wrote about. If you think about the Morocco-Nigerian, trade agreement, investment agreement, where everybody was happy about that. I think in part, maybe lobbies may have played a role in this, but they were not also the sole actors. They were African agents that, there's the Agency of African Scholars, some of whom we know, who were involved in the drafting. I don't have firsthand information about what they did, but I think they are the ones we have to ask, why did they do this? They were trying to circumvent the more difficult question of how, if I were to offer a generous interpretation, I would say they're trying to circumvent the problem, right? We're trying to satisfy panels on what constitutes economic development and which of those measures you would account for. But inadvertently, if it were to really be put to practice, I think it sets a barrier that will never really be broken. So I think it flows better into your question then, right? So what then, right, do we do? Clearly the case is not to forgo all these things or to make them say it's not possible, right? Or to make it impossible, to work with. I think, I started hitting at it and it's not an idea that has formed fully, but I think safeguarding policy space is one thing, which I think the agreement clearly does, which probably has done too much, right? But actually working within the realms of the policy space you now have to really drive investments is a totally different thing, right? And that's where I think we may struggle with this particular agreement. So to the extent that, for example, Nigeria, and again, maybe the workings of this has some flexibility that I don't know, but to the extent that they need to achieve certain kinds of investment, for example, they need flexibility to allow them to say, okay, at this point, we need you to actually move and go and deploy. Some people, I haven't read it, but lithium extraction in Nigeria was an arbitration review over the past 2 or 3 days. I have the PDF, but I didn't get to it actually, right? But the issue really is that to the extent that Nigeria has actually tried to draw investors and they are now here, there's now a big question mark around how, right, they'll move forward with the sort of investment they're making. So I'm trying to think beyond academic debates here. that just says, oh, look at these agreements that typology have. The actual workings of these things on the ground really remains very difficult. And the attraction you need to have these high net worth investors come to the country is really not happening at the place, at least we think we would like it to do. So yeah, to be safe with time.
There, yes, I go there. These are not easy questions. Probably I will pick up on the enforcement and why labor is treated a little bit different from the labor perspective. I think if we look at the trade and labor link, what we see is also narrowing down a little bit. If we think about the rapid response mechanism, it only looks at right to collective bargaining and freedom of association. Forced labor good bans are only on forced labor. So the general approach that FTAs and GSP plus system have undertaken is being fragmented with recent measures. And I think if we look at the literature, if we look at all the studies, I mean, in the last 10 years, everyone has tried to see whether labor provisions and other provision in free trade agreements had actually an impact on labor standards on the ground. And what we see is that they have very little effectiveness. Maybe one of the reasons why is that the approach was very broad. All the ILO fundamental principles and rights, and then we have widen. Probably this may be a reason, and this is why maybe these new measures can complement in a way. That doesn't mean that free trade agreements and trade and sustainable development chapters, trade and labor, trade and environment, whatever we can call it, are not useful. They are, but I think we need, in a way, to rethink about the potential they actually have. Again, they try to, at best, reduce state level enforcement gaps, for instance, in labor inspections and so on and so forth, but they cannot really change labor rights in another country, which in any case, it's a very sensitive issue, and states are very careful about that. And the other point is about why labor and not the others, or the others are kind of lagging a little bit behind. The trade and labor link is there, even though it's very undeveloped. And a lot would say that also the labor-related provision FTAs, again, they didn't achieve much. But again, first labor good bans, they link the measure to the actual products that have been produced with the violation, which is something that we do not see in other instruments. It can be promising. It could be a little bit more difficult with other human rights than labor. But again, maybe we also have to think about the nature of free trade agreements, which are not free trade agreements anymore, and which are probably more general partnership agreement with a lot of different chapters, many of which are related to trade, but not exactly on trade. And probably we have multi-package agreements in a way addressing different ways and different rights.
Thank you. Thanks so much for the questions. Starting with Liz's question, having sort of binding agreements versus non-binding. I guess I'm not sure is the answer, and I'm cautious with New Zealanders in the room who could answer it better than I could. But I think that from New Zealand's standpoint, for those who don't know, this goes a little bit to Junji's question. New Zealand liberalized. Removed most of its trade barriers unilaterally in the 1980s. And so it's a very unusual country in the world to have done that. And so New Zealand is starting from a different posture in all these negotiations because it's already sort of opened up. So it's like, well, how do you get others to do what we've already done? And so it's I think, a constant driver then to try to be creating some sort of new value, extra reason why you should engage with New Zealand, because some of it you're already getting. So I think from New Zealand's perspective, it might for certain things be better. Preferable to have a WTO agreement, but New Zealand would rather have others do some of the things that New Zealand is doing than have some doing what New Zealand is doing than have no one doing what New Zealand's doing. So I think New Zealand's pretty pragmatic about that. And I think for some of these sort of inclusion, sustainability issues, because there's not these sort of market access types of issues even at play, many of these things are things that New Zealand wants to do anyway, feels is important to do. And so if it can convince others to do it the way New Zealand is doing it, that's a win. And I think that New Zealand's general approach, the ministry's general approach is, if there are going to be rules, we'd like to be involved in setting them, because then it's more likely they'll be the way we want them to be, as opposed to some way that we don't want them to be. So New Zealand always wants to be at the table. And while I really emphasize this around New Zealand, there have been some frequent collaborators that pop up again and again. And so, New Zealand and Singapore have been partners in a lot of things, New Zealand and Australia, New Zealand and Costa Rica. There've been certain other countries that are very much simpatico on some of these issues, but not all of these issues. Yeah, so that's what I'd say about that. And then, Junji, I think part of the answer is what I just said about unilateralism. And also, so New Zealand has had to be creative, right? In terms of all of these sorts of things, it's better for New Zealand if others are involved, because if it's just a negotiation between New Zealand and some bigger country, that might not go New Zealand's way, and it doesn't always go New Zealand's way. But if you can convince, WTO members to pursue something, that's really great for New Zealand to reap the benefits of that. But I think New Zealand picks and chooses its issues and tries to look for things that might gain traction, right? And so that has been helpful. I think because New Zealand has a very small population as well, that while there are differences between political administrations, there's less of a us-them type of view towards the economy. Sort of if I take the US, we have, big companies are doing things and the people are being affected. And in New Zealand, like, the people running the companies are your neighbors, and, your kids go to school together and stuff like that. And so I feel like there's more of a communitarian, collective ethos about problems. And that may lead New Zealand to kind of take the lead on certain things. And of course, as an island and a small island, things like climate change, plastics pollution, things like that are real. These are not abstract problems. Whereas I think, well, it's not an abstract problem for the US. We have a lot of fat cats who make money off of continuing to spoil the environment. I think New Zealand has more of a collective view about the environment and things like that. So yeah, hope that helps.
Thank you, Meredith.
Thank you. And thanks for the wonderful question, the one from how we can just get to reality, and another from that how to bring the more members in. And for the reality and how to bring the members in, I think that it actually have some comments. Right now, I think that if we just can see all the topic of the panel, we just talk about the hard laws. It will be the traditional, the mega, the free trade agreement, and then we just move on to the sectoral agreements like APEC, and then we just talk about the EU CSDDD and its original rules. Actually, it's just transfer from international soft law into the hard law. It will be an example. So I have ideas that when we want to ask that how we to bring more the members in, of course that it will just like the story that between the wind and the sound, and when the wind and the sound they just want to bet that can we just bring more people in, and or just to be persuaded to see how strong you are. Probably the wind will be push people away, so the sound is meaning the software way will be the first. It will be a first step, right? To bring the members in first, and then we just to sit down and to talk about that how we can just say and how we can just take actions, and then we just move on to the hard law bit by bit and step by step. So probably that's when we just have the APEC, it's kind of the cooperation central the agreements. Then when we just can to communicate and to collaborate, that how to identify the trade norms that probably it will be possible and feasible and add into the trade agreement. Then we can try to bring the more specific chapters, specific provisions, and then we can try to add more. Add more, it means that we can use the import or the export control measures, and then the new mechanism, the forced labor mechanism, then add into that and to increase its enforcement. So I think that right now, the more and more countries, they want to explore more the new ways. And those ways, that my idea is that probably we can try to combine them and try to make them to a more strategic framework. And then probably they have the different stages. The first stage probably will be like IPECA, and or the second stage will like the gender clause in the trade agreement. There's another step, the third step probably will be the forced labor mechanism. Then we add more the trade measure. And then final goal is that we will want a very strong and probably will to combine the hard law and the soft law chapter, and then try to bring more people try to want to do this same action. And then of course that when we try talking about enforcement, that we can just see the EU's CSDDD. Actually, he tries to get the private sector engaged in. I think that it will be the important part right now. Probably that we can just think about how to we just reform the trade agreement, to bring more the private sector in. So not only the trade and the sustainable development chapters in EU trade agreement, but also probably we can just bring the more is that we try to ask the government, even we try to directly to ask the private sector, so you must have to do your due diligence, and even you must implement your CSR, corporate social responsibility. So if we can just go to that step, probably we can just bring the gender and the other social environmental issues, and then just to into probably the part of the trade agreement or the side agreement to the trade agreement. So it will be my ideas, and probably I can just add something to the forced labor mechanism and the gender, because I remember that I just to read the U.S. government's his trade policy report in 2023, and he just mentioned at that time the United States government, he very proud that they have a new the forced labor mechanism, and he just mentioned one sentence, say they will use this mechanism to promote the gender issue. I think that will be a wonderful idea, because the labor rights, it will link to the gender, because gender equality in working condition and in working environment. So probably that if we want to more the stronger gender issue, we can try to use right now existing the mechanism to link in the different issues, even though they are the trade issue, but probably that if they have some issue, they have stay stronger. They just to go further or faster than other non-trade issue. Probably we can try to do some pathway ways and try linking to the hinge on other issues, then try to bring all the social and environment issue to have more enforcement. So that will be my ideas. Probably can just answer your question. Thank you. And
yeah.
Yes. Thank you.
So I don't think any question was particularly addressed to me, but I'll take this opportunity actually to ask a question to BC. Yes, you see. So I was intrigued by what you were saying with the characterization of investment as something to be an investment. And if we look at the case law, the Salini test, which was the test according to which you could characterize something as a foreign investment protected under a BIT, and that was developed by the courts. And one element was precisely, is this investment contributing to the development of the host country? Now, this was down to the courts to determine. And because you referred to this as some sort of significant aspect of this agreement, I wonder whether you think there is any way in which host states in the African region can, to some extent, constrain how tribunals will determine whether or not an investment can be characterized as a sustainable investment. I think it's crucial to, in a way, making this provision relevant and significant, because otherwise, as you said, how will the tribunals determine whether or not effectively the investment respected the local laws? And I mean, obviously they will look at domestic laws, but here they will look at domestic law as a fact. So is there any way in which, African states can, to some extent, constrain tribunals?
We'll give BC some time. Okay. So I can collect some questions. Like, anyone has a simple, concise question? You mean?
Thank you so much. I have one question for BC, similar to Team BC question. So I was wondering if you can elaborate a bit more about the threshold is too high. The threshold, do you mean like the concept of sustainable development? Because I think this concept is really contextual, case by case, or the significant as the threshold. And one very simple question to Ilaria. So Canada include not only forced labor but child labor. So I was wondering, could you please elaborate why child labor has been included in Canada's like this kind of regulation? Thank you.
Ying-Jun made a very important point. We need to include more countries. Maybe that's the way to go. But then I want to connect to what Meredith said. New Zealand is doing this because it wants to be the rule setter. And that's a fact. We look at BITs, we look at trade agreements. I think developed countries have acted as the global agenda setters. And as a result, the entire discourse on inclusion in trade and investment agreements has become a discourse by developed countries, designed by and controlled by developed countries. And do we see that as a problem? If that's a problem, sort of how can we try and address this, right? Because that's throwing the developing countries further away from the table.
Yeah, I actually have a question for Tibisay. Yes. So Tibisay talk about due diligence directive, and do you think this type of directive will be incorporated into EU agreements? And more importantly, how would EU trade partner respond to this type of agreement? Because I am thinking of CBAM, right? The European like talk about CBAM, but actually what happened on the ground is that most Asian countries in the regions are talking about how to deal with CBAM, right? So countries actually see it as a problem. And also for Meredith and for Ying-Jun. So Meredith, you mentioned a lot of important innovative agreements, but actually other than SDCTS, all other agreements are soft law, right? And what are the tangible impact on countries and enterprises? And also for Ying-Jun, you mentioned the PECA, which is of course a groundbreaking agreement. So I'm thinking of GEA, Green Economy Agreement. A Green Economy Agreement is technically non-binding. So the goal is actually incorporate the GEA into an FTA. And this is what Singapore negotiator had in mind. They never said it, but this is what I had in mind. So I'm not sure if IPECA will follow a similar approach. Okay, good. So I give every panelist 1 minute to address this issue. Oh yeah. Okay. So Tibisay.
Okay. Yeah. Well, very interesting question. I actually hadn't thought of it in the sense that with every directive, you give member states time to transpose it into domestic law, but effectively then it becomes part of their domestic law. You are right, though, that because all member states will need to transpose the directive, there will be some element of harmonization in terms of trying to raise standards when it comes to human rights and environmental protection. So you could have a scenario in which the EU, when negotiating an agreement with a different country, could incorporate by reference, either the reference to the directive or the directive as transposed into domestic law, and then ask the counterparty to some extent commit itself so that companies based in that counterparty are aware that these are the standards. And this will be a way to handle the extraterritorial reach, because that then partner will agree to the standard itself. But I don't know which countries would do that. And I perhaps New Zealand, perhaps, countries. I find it difficult for developing countries as such that might want to prioritize development over certain other values for a good reason to sign up to something like that.
Thank you very much. Thank you very much, Tibisay. Okay, Ying-Jun?
Thanks for your question. The first that I will want to respond to the America. Yes, that will be a huge problems, especially also is this in indigenous people, because we can see even the APECA is in the Taiwan, New Zealand, Canada, they have a high income country. So how we can try to get the Asia-Pacific country, especially the Southeast countries can get in, that really will be the issue we must think about, like how to bring. So that probably will touch your real critical issue, like how to close the gap between the developing countries and the developing country on the standards. So I will figure out it also in the future as you will. And then, so that will be the Pasha will just to pave a way that if it's possible that to include this kind of the APECA into the free trade agreements, of course that it will be my hope and it's my wish that I can try to use the free trade agreement as the platform like to get the turn the soft load into the hard loads and to get some of the trade sensation. But it will depending on which country want to take this first step. Probably the New Zealand. We will wish the New Zealand can just take the first step. Yeah, thank you.
Yeah, we don't know if Caroline and Tracy would agree. Anyway, Meredith.
Yeah, thank you. So I think that soft law and hard law are not necessarily binary choices. Some things can start as soft law and then become hard law. Things can start in an FTA and spread to other FTAs or be multilateralized. Things can start in soft law and then end up being FTA chapters or et cetera. So I think if the choices don't have anything or have soft law, New Zealand would probably go for soft law, but might have aspirations to have it, hopefully have it become more binding in the future. But I also think there might be different aspirations depending on the nature of the agreement. For example, the way New Zealand itself deals with Indigenous issues, I don't think New Zealand's trying to ram down the throats of other countries the way they handle their own Indigenous populations. It's just, it's important to do right by your Indigenous populations, and they are the Indigenous people of your land, and you should deal with that. Yeah, so I think that there's just contextually there may be differences, but if with the environmental goods agreement, with APEC unilateral, deciding soft law, hey, we're going to do this, that wasn't enforceable, but everyone agreed to do it, and everyone did it except for one country. So that was meaningful.
Thank you very much. Ilaria?
With regard to child labor, the definition of forced labor is, let's say, non-age specific, because it just simply say any work of service which is performed by a person under the menace of threat of penalty with involuntariness, right? So forced labor good bans, of course, apply also to child forced labor, so any case of child labor which is also forced. But then in some cases, for instance, with the EU forced labor regulation, then the definition of forced labor in the regulation, they wanted to be, let's say, extra careful. So they say this also includes child forced labor. With regard to Canada, it is up to now the only measure in which they introduced the forced labor good bans first, and then in 2024 they changed, and they also add child labor. And in that case, it means work performed under 18 years old under certain conditions. And if we look at the condition, actually it's very much linked to forced labor. So it's not any kind of child labor, so any kind of work which is performed by people under 18 years old, but it has to be below 18 years old with other conditions. So the fact that the work is arduous, that the work doesn't allow the person to go to school, etc., and etc. So this is the only measure so far that also includes cases of child labor that could be a little bit beyond forced child labor. But for so far, this is the only one we have.
Excellent. Okay, so BC, you have the last minute.
Thank you. So thanks, TB and Yiming. I think the first way to respond to it, which I didn't get to, is that, again, if you think about what's going to happen with North-South agreements, generally in trade context, but broader IIAs, right? This does not relate to them. So they have the free will to continue to find ways to circumvent, right? And have their investment done, right? So that's why I said it's gone a bit too far. That's what one instance of what I mean. But I've ordered another works where I talked about Africanization of international investment agreements and I've forgotten his name now. There are those who believe that these kind of agreements don't make any kind of progress simply because they don't change the needle or they don't move, anything on the broader context of it. I actually disagree with that. Can they constrain, in other contexts? I don't think so, but I think that's precisely what they tried to address, right? The Salini test. But in so doing, it has constrained. And I think it's the limitations of rules and drafting, right? When we come to the context of agreements like this. And so characterization of innovation shouldn't just be limited to insertion of this kind of sustainable development language, right? Literally in all of the agreements. I think more careful ways in which we think about them, even in the broader context of, say, trade for African countries. It's not about trade, as it were, right? So some of these languages are not quote unquote new if you look at trade agreements in Africa in themselves, right? But their exportation into the context of investment agreements has a totally different ramification, right? Once you think about it in the broader context of the real place where investment is playing out, which is investors coming into the country from outside of the continent and not just within the continent.
Excellent. Please join me in thanking the panelists and our student assistant. Yes. Yes, thank you very much for coming. And we know that we need to convene downstairs for dinner, yeah, which is very important. Yeah, yeah. Panelists, let's take a good photo. Yes. Yes.
Fantastic. Thank you. Well done. Yeah.